Now, whether Parliament on its own can change that status is a separate issue, but the legislature cannot change that status. That's the element of permanency as far as the legislature is concerned. Let me put the Legislative Assembly also can't touch below the provision that the state of Jammu and Kashmir and shall be an integral part of India. Section 3. It also can't. Nothing more than that. We're not amending the Constitution of India. We're amending the constitutional order applicable to the state of Jammu and Kashmir, which makes 370 applicable. The whole scheme of 356 is if you take over.
Parliament can do it or not.
Yeah, well, Parliament exercises the powers of the legislature under 356. It can't exercise any other power. And that's the scheme of 356, which I'll come to later. That's Bomai Malas. Now that's settled. You can't arrogate to yourself a power that the legislature doesn't have. That's why there's an interplay between the Constitution of India, the Constitution orders applicable to the state of Jammu and Kashmir, and the Constitution of Jammu and Kashmir and 370 itself.
That's what you flagged in the beginning when you began your speech.
That's the issue.
Actually, Article 147, the second proviso to Section 147 of the J&K Constitution, would seem to indicate that the provisions of the J&K Constitution are treated to be subordinate to the Indian Constitution. Which is why no amendment in the relationship of the Indian Constitution and its application to the state can be introduced in the state legislature. The state legislature cannot change that relationship.
Correct, but I'm not disputing that. It is the legislature cannot introduce a bill to that effect. And what's the procedure? Only under 370. It's only under 370.
But this is in that sense a subordinate instrument in its application to the relationship to the Constitution of India.
But let's kindly see, one second, kindly see, just 1 minute. Kindly see the Constituent Assembly has now framed the Constitution. The Constituent Assembly has not exercised the power that it had, to abrogate 370. In that process, the Constituent Assembly, when drafting the Constitution, decided that nobody can change that status. The legislature cannot change that status. Now, whether Parliament on its own can change that status is a separate issue, but the legislature cannot change that status. That's the element of permanency as far as the legislature is concerned. Let me put it that way.
The legislature has no authority to change the relationship between.
That's correct.
That's what you're saying.
Change. Why? Because this is not a temporary provision. The Legislative Assembly also can't touch below the provision that the state of Jammu and Kashmir and shall be an integral part of India. Section 3. It also can't touch extent of executive and legislative power of the state. Can't touch that. It can't touch 370. So from the point of view of the Constituent Assembly, when the legislation was drafted and the Constitution was drafted, it was clear that this relationship is permanent.
Just one question. The proviso to Article 147 of the J&K Constitution says that no bill or amendment seeking to make change in the provisions of the Constitution of India is applicable.
Yes.
In relation to a state.
Yes.
Means a change in the Constitution of India. Whereas as per clause 3 of Article 370, it's not the amendment which is applicable. As per that, it's the consent or the consultation or the
recommendation. Neither consent nor consent. It's a recommendation.
No.
Of the legislature.
Let's see 373. Let's see 373 for
yes,
a minute.
Please.
So really speaking, under 147 may have no application as far as because you're not seeking to amend 370, but enforce 370. Let's assume, for the time being, substitute the words Constituent Assembly for Legislative Assembly. On the recommendation,
Yeah,
let's assume so.
yeah,
Let's substitute, you're right,
Correct.
recommendation.
correct.
Let's substitute that word, provided that the recommendation of the Legislative Assembly for the state referred to shall be necessary before the President issues such notification.
Yeah.
So really, 147 will not be applicable in case the state legislature makes that recommendation.
No, but let's kindly see what 147 says is the provisions of the Constitution of
What?
India
You're not
as
amending the.
applicable in the relation to the state.
You're not amending the Constitution. You're not amending this Constitution of India. Let's, for the time being, let's read as it is, because what is barred under the proviso to 147 is amendment seeking to make a change in the provisions of the Constitution of India.
As applicable in relation to the
As applicable in
Which
relation
is,
to the
which is
state.
why 370 is incorporated, Malad, in the Constitution of Jammu and Kashmir. As it stood then, that's the application order.
Mr.
We're
Sibal,
not talking about the Constitution of India here.
Sibal, doesn't it, I'm just thinking aloud,
Yes.
does it not mean that the proviso, the implication is that once the provisions of the Constitution of India are made applicable by different orders,
Yes.
you through an amendment cannot
That's all
deactivate
that
it.
we are saying. Nothing more.
Deactivate a provision which has already been applied to the
Yes,
Constitution
that's all that we are saying.
of,
Nothing more than that. We're not amending the Constitution of India. We're amending the constitutional order applicable to the state of Jammu and Kashmir, which makes 370 applicable. And it can't even be moved in the House. And if it can't be moved in the House, it can't even move the bill. It can't be moved in Parliament.
as I see it, it's that you can't go back. Suppose after consultation, the CO has been issued, order has been issued, notification has been issued, certain provisions of the Constitution have been made applicable.
Yes.
Then it's not that a rethink can arise 10 years later and
Yes,
you start
that's all. That's all.
and say that, look, okay, we don't want to make some of the Constitution provisions
Absolutely.
already made applicable,
Correct.
not applicable.
So my argument is that the Constituent Assembly has exercised its choice. And it's evident from the provisions of the Constitution itself. So you need to read the Constitution of India, the orders applicable to Jammu Kashmir, the Constitution of Jammu and Kashmir, and 370. So under what provision of law under the Constitution of India can you change that? When you are doing it under 370, 356. So now, Malaj, this is now the lay of the land as far as this is concerned. Now I want to take your lordships to the judgment of Supreme Court, Malaj, of this court in the power of the constituent